Today, we're stepping into the courtroom of Judge Raquel West, where patience is running out and second chances are fading fast. From drunk driving deaths to broken probation promises, every case in this session tests the limits of accountability. Watch how Judge West delivers firm justice with no hesitation and no excuses.
Good morning, you're Adam Moe. Okay, so we're here because Mr. Moe is on probation.
Yes.
I did a different type thing where Mr. Moe went and did some time on some of his cases in prison, got out and is now on probation. Apparently, there are some potential issues with regard to where he's living that weren't issues with parole, but are issues with probation. Is that correct?
It sounds like they may be issues with probation.
Okay.
That's kind of why our original emergency motion had a strange title, because we didn't know what else to call this.
Sure.
Other than in an effort to make sure that he is doing everything correctly. I think our mission on that was, let's get in front of the court and make sure this is being done correctly.
So what's the issue, potentially?
Adam's parents, Jody and Chris Moe, who the court may remember, and they're present again today, while Adam was incarcerated, went to a number of links with the folks from parole to make sure that any home that Adam was going to live in upon his release and beginning the out of prison portion of probation and parole, because he's on parole too.
Correct.
That their home where he was going to live was in compliance.
Right. Parole's approved it.
Parole has approved it.
So where are we?
If the court doesn't mind, I'd rather not say the address.
No, I don't need that. I just need to know what the issue is with probation.
The issue is we are at 574 feet from a church that has a playground attached to it. And I don't want to speak for probation at all, but condition, I think it's 33. It isn't vague, but it's neither inclusive nor exhaustive. So I don't know exactly what the conversation was that probation had with Adam the day that he reported immediately upon his release from prison a couple weeks ago. And I don't believe that the conversation was, hey, you can't live there. It was, this is kind of an issue. So our position is a lot of effort was made.
So what's the issue?
Excuse me. So his condition number 33 says that he's not to be within 1,000 feet of places where children commonly gather.
Right.
So it's not limited to that list. And so I believe it's the 574 feet from the church with the playground attached is the issue.
Okay. I'm looking at the order now. Off power, any strong feelings one way or the other?
Judge, we'll leave it to the discretion of the court. I understand what probation is worried about.
Sure.
Set them up to fail. I do understand that's unique with parole and probation, two different entities, but
Well, and
I
the
don't want him
offenses
violated.
were possession of child pornography.
correct.
There weren't any allegations of
There were 10,
assaults or anything like that?
Correct.
Okay.
just 10 charges of possession. And 5, we put 5, got penitentiary and 5 with probation.
Right. Is there a GPS at this point?
No,
See,
As
he
a-
hasn't had his initial, actually, the assignment is tomorrow. He just did intake and correct me if I'm
Sure.
wrong. He just did
No, and I
intake.
appreciate being proactive, and that is good. We don't want to be in here the first month because there's a violation, which technically that would be a violation. There's no doubt that it's not vague. That would for sure be a
No,
violation.
in my reading too on the geography of this thing, Judge, is that if Adam were to make, I'm going to call it a left turn if I've got the map correct in my head. If he were even to turn incorrectly down the main street where this house is, that would be a parole violation. So our position is that parole's assessment here, and I know the numbers are what they are, but that if covers both issues. So it's not like there's some kind of leeway to go even closer to that facility. He isn't going that way. He cannot, or he's in violation of what's been set up forward.
Judge, Ms. Roach says if he lived there when he sentenced him, he's grandfathered.
He's not, though. They specifically moved to
Okay,
make, thank you, though.
yes.
Miss Roach is watching to make sure, because if you were living somewhere already, there's kind of a grandfathered in, but they specifically moved to try to make it better. And
Yes, ma'am.
okay. Well, here's what I'll do. I will allow a modification of number 33. But I want it to somehow, some type of addendum or attachment that's very specific, because this isn't going to be a exception for all, only for this specific. So I will need probably the address of that church, so that in the orders, it says that you can be within 574 feet of that specific place. 33 stays the same for everywhere else. So it can be 33 can read like it does, and then you can add with the exception of that one place. Also, at least for, I would say, 6 months or so, or depending on how probation feels once he gets going, and if he's following all the rules and treatment and things like that with the LSOTP and all of that stuff, then I want a GPS monitoring device on at least for a minimum of 6 months to make sure that the rules are being followed, that he's going the right way, and there's not any issues. And that way, once we're all more comfortable with how things are going now that he's out of prison, then I'm okay with getting rid of that once you're okay with that, if he's following through with treatment and everything like that. Make sense? Okay?
Just one question. I think there's not a school.
It's not the school issue, it's just the church.
The church. Yeah, the church with the, so I want that, that's the only exception, and the exception is the 574. So like you said, turn the other way, don't get any closer than what you're saying. That way there won't be an issue with it being any closer than what you're saying at any times that it would show up on that GPS. Make sense? Okay?
Yes.
All right, thanks. Y'all are free to go. No, ma'am. Mr. Burbank, Renisha Chason. Mr. Chason tested negative for everything, so that's good. Thank you. Yes, thank you. I need your signature, though. All right, ma'am, you're Renisha Chason. And will she waive the formal reading of the indictment?
She will, Your Honor.
And again, we're just going to get a plea on the new indictment, reset the MTRP case, and come back and see where we are with the pre-sentence report. Is that correct?
That's correct.
Okay. That goes with that also.
Judge, just to refresh the court's recollection, the co-defendant in this case, who is the, in my opinion, much more culpable defendant, has already pled the TDC time.
Okay, thank you. Ms. Chason, in cause number 24, DCCR 2351, you're charged with the second-degree felony offense of injury to a child, and that's from July 19th of 2024. And how do you plead to that charge? I'm sorry? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they've charged you with? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Burbank? And do you fully understand them? And do you understand, if I follow the agreement that you made with the district attorney, that you'll be waiving or giving up any right to appeal? So if I follow the agreement, you can't change your mind later. Do you understand? And it looks like the agreement that you've made is for a 5-year deferred adjudicated probation, There would be a $500 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding? Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State to nurse number one.
No objection, states one.
It's admitted. Is there any evidence that Ms. Chaison's not competent?
No, Your Honor.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, but I'm going to reset your case so that the probation department can do a pre-sentence report. And if that can include an update also on the probation case where the motion's filed, so I can have all that information as well. And then we will come back at a later date for sentencing. You need to stop and talk to probation on your way out of the courtroom today, and she's sitting at that desk right over there. All right, we'll see y'all back at sentencing.
Would the court consider allowing her to remove the drug patch? It's costing some money that she doesn't have.
Not until sentencing. We're gonna keep it on until sentencing. Make sure you keep it on and keep it updated, and then if everything goes well, it's about 5 or 6 weeks. Okay?
May be excused.
Yes, thank you.
If you're watching this far, you clearly love real courtroom drama. Don't forget to subscribe and hit that bell icon so you never miss when justice gets personal. Each week, we bring you real cases, real people, and real consequences straight from the courtroom floor.
All right, again, sir, you are Ray No.
Yes, ma'am.
And Mr. No, in cause number, hold on, let me get it pulled up. Cause number 25 DCCR 0386, you're charged with a second-degree felony offense of intoxication manslaughter with a vehicle from December 11th of 2024. And what that means, sir, is that if you go to trial and you're found guilty, the range of punishment would be between 2 years and up to 20 years in prison. Do you understand?
Yes, ma'am.
And then in cause number 25, DCCR 0387, you're charged with the state jail felony offense of driving while intoxicated with a child under 15. In the same offense date of December 11th of 2024. And in that case, if you're found guilty, the range of punishment is between 6 months and up to 2 years in a state jail prison. Do you understand?
Yes, ma'am.
I have here on the tablet in each of your cases plea bargain rejections that you've signed with your attorney that shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty. In the intoxication manslaughter case, that offers for 18 years in prison. And then in the
Should be
2 years state jail.
Yeah.
No, okay,
Yeah.
all right. Okay, if I make that modification.
absolutely,
Thank you.
Judge.
So in the other, well,
And if you can't read my writing, I'm
nope,
happy
that's
to-
okay. I'm obviously don't know how to erase because now I'm just making marks all over this document. I feel like I know how to. Okay, so, good grief. It is a Monday. All right, so in that state jail felony case, the offer is for 2 years. In the state jail prison, it would run concurrently with the other case. You have every right to reject these offers and have both of your cases set for trial. I just want to understand, make sure you understand what the possible consequences are if you go to trial and what your options are. And do you understand all of that?
Yes, ma'am, I understand.
And do you want to reject those offers and have your cases set for trial?
Yes, ma'am, I do.
Okay, we'll get that done. And Mr. Coleman, is there any reason to believe that these offers would change? Is there any evidence that you're waiting on or anything like that?
No,
So I do want to make sure you understand that after today, Mr. No, I won't accept this plea agreement. If you change your mind and want to enter a plea of guilty, that would be to something different or open to the court, unless there's new evidence that your attorney or the district attorney gets or finds out about between now and then. Make sense?
Yes, ma'am.
Okay, we'll see y'all at trial. We'll get it placed on the trial docket.
Thank you, Your Honor.
Thank you.
Your Honor, may I be excused?
Yes, sir, thank you. Yeah. See, Mr. Valles?
Yes, Your Honor.
Good morning, sir. On Crystal Calvillo,
Yes, Your Honor.
Calvillo, I'm sure I'm saying that wrong. Good morning, sir. Good morning, ma'am. You're Crystal Calvillo?
Yes, ma'am.
And Ms. Calvillo was previously in court and cause number 24, DCCR 2456, entered a plea of guilty to the state jail felony offense of theft of property. I've received that pre-sentence report. Any additions or corrections to that report?
No, Your Honor.
No mistake.
All right, ma'am, I'm going to find that you entered your plea of guilty previously freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 3 years.
Yes, ma'am.
You're ordered to pay the $500 fine and to follow all of the rules and conditions of probation. If you do that, this is an excellent opportunity because you do not have the felony conviction on your record. And at the end of that probation period, if you successfully complete it, the case is actually dismissed and you will never have that felony conviction. The other side of that, though, is if you violate any condition of probation, you can be brought back into court, you could be found guilty, and then you could be sentenced anywhere in the range of punishment, which is up to 2 years at a state jail prison. Do you understand? And there's no restitution, correct?
No.
Okay. All right, I'm handing you the trial court certification that shows this was an agreement that I followed, and so you have waived your right to appeal. If you'll just have a seat here in the courtroom, probation, she's going to call you up to her desk when she's ready to go over all of your paperwork.
Thank you, ma'am.
Good luck to you, ma'am. Thank you, sir.
Thank you, Your Honor.
Ms. Holmes, you've got a sentencing on Cameron Gutierrez. Sentencing on Cameron Gutierrez. Good morning. Good morning. Are you Cameron Gutierrez?
Yes, ma'am.
And Mr. Gutierrez was previously in court and entered a plea of guilty to evading arrest or detention with the use of a vehicle in cause number 25 DCCR 0325. I've received that pre-sentence report. Have you both had an opportunity to review it?
Yes, Your Honor.
Yes, sir.
Any additions or
None from
corrections?
the defense.
No mistake.
All right, sir, I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 2 years. You're ordered to pay the $500 fine and to follow all of the rules and conditions of probation.
Yes, ma'am.
If you do that, this is a great opportunity because you do not have a felony conviction on your record. And if you successfully complete the probation, at the end of the probation period, the case will be dismissed and you'll never have a felony conviction. The other side of that, however, is if you violate any condition of probation, you can be brought back into court, found guilty of the offense, which would make you a convicted felon, and sentenced to prison for anywhere in that punishment range, which is between 2 years and up to 10 years in prison. Do you understand?
Yes, ma'am.
I'm handing you the trial court certification that shows that this was an agreement that I followed, and so you have waived your right to appeal. If you'll just have a seat here in the courtroom, probation's going to call you up to her desk when she's ready to go over your paperwork. Good luck to you, sir. Thank you. Mr. Kelly?
Work to be here, though.
That's right. Good morning, sir. You are John Van Wright, and this is 24 DCCR 2485 and 15 23582. What is the announcement?
As far as the MTLP, it would be not true, Judge.
Okay.
I feel that you're not.
I think we'll just prove up the MTRP first, Judge.
Okay, so let's do this then. Let me get that pulled up. We'll go through that entire motion and then we'll get an updated report and set it for sentencing. Mr. Van Wright, would you please raise your right hand? Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth, so help you God? Thank you, sir. And will he waive the formal reading of the motion?
Yes, Judge.
Mr. Van Wright, in cause number 1523582, I have a motion to revoke your community supervision. Shows that you were placed on probation July 28th of 2020 for the third-degree felony offense of injury to a child, elderly, or disabled individual, and that was a 10-year term in prison, but it was probated for 6 years. Is that correct? It alleges that you violated your probation. Count 1 alleges that you committed the offense of injury to a child, elderly, or disabled individual November 14th of 2024. And is that true or not true? All right, did you enter your plea of not true to count 1 freely and voluntarily? All right, then I'm going to enter that plea of not true on that count. I'm going to reset the case for sentencing hearing. About how long do you anticipate?
I want to know more than
About an hour or so, so we could do it maybe at the end of a docket? Sure. So we'll set it for 11, probably on a Monday, just at the end of one of these dockets, unless I can find a time when we're not in trial on another week.
Okay.
And that'll give y'all time for any
you can
evidence.
just let me know, or have Kelly or somebody let me know so we can get witnesses here.
We'll do it. She'll be back tomorrow, and we'll get that set in the next couple of days. If I can get an updated pre-sentence report, that would be great as well. And then we'll see y'all back at sentencing. All right?
Good, Judge.
Thank you. We need to get his print, please. Yeah, make a note for Kelly, though, that it needs a hearing about 1 hour. We probably can do it on a Monday unless we find another day.
Yeah, I think this one's Judge.
Yes, thank you. Mr. Rennick, you have a sentencing on Alexandria Bledsoe.
Yes, Your Honor, she's correct.
Sentencing on Alexandria Bledsoe. Good, how are you doing? Thank you. Good morning, are you Alexandria Bledsoe? And this is 25 DCCR 0004. Ms. Bledsoe was previously in court and entered a plea of guilty to the state jail felony offense of abandoning or endangering a child with intent to return. I've received the pre-sentence report. Has everyone had an opportunity to review the report?
Yes, Your Honor.
Yes, sir.
Any additions or
Only
corrections?
one minor thing my client would bring up. The name of her employer was Cigna, correct, or Sigma? Sigma, it was listed as Sigma, and she was just worried that that might be an
Okay,
issue. I told her not to worry
Don't
about
worry
it,
about
but
that.
she wanted to bring it to the court's attention.
okay, thank you very much. Anything else?
So, Your Honor.
All right, ma'am, I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 3 years. You're ordered to pay a $500 fine and to follow all of the rules and conditions of probation. That is going to include completing an intensive parenting class. If you haven't already done that through CPS, there's going to be something through probation that you're going to need to do, obviously. If you do everything that you're supposed to on this probation and follow all of the rules and conditions, then this is an excellent opportunity because you do not have a felony conviction on your record. The other side to that, though, is if you violate any condition of probation, you can be brought back into court, you could be found guilty, and you could go to the state jail prison for up to 2 years. Do you understand? Okay, obviously, I would like to think that this was a huge wake-up call because this could have been very, very bad. And so take care of your child, take care of the classes, make sure you make all of the right decisions when it comes to that, and you shouldn't have any issue. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. If you'll just have a seat here in the courtroom, probation's going to call you up to her desk when she's ready to go over your paperwork. Good luck to you, ma'am. Thank you, Mr. Rennick. And Mr. Rennick, you also have...
What an intense session inside, Judge. Raquel West's courtroom. The day began with Adam Moore, a defendant already on probation who couldn't stay out of trouble. His record showed repeated violations, ignoring probation rules, causing disruptions in custody, and refusing to take the program seriously. Judge West reminded him that probation isn't a right, it's a privilege. And when someone keeps throwing away that chance, incarceration becomes inevitable. Adam's story served as a harsh lesson about wasted opportunities. Next up was Risha Chasm, a young woman who found herself back before the court while still serving probation for past charges. Despite being given leniency before, she now faced new criminal allegations that completely undermined her prior plea deal. Judge West questioned her choices, stressing that rehabilitation can only work when the person truly wants to change. The look on Chazin's face said it all. She knew this might be the end of her leniency. Then came one of the heaviest moments of the session. The case of Michael No, charged with intoxication manslaughter. His drunk driving had cost an innocent person their life, leaving both families shattered. The courtroom fell silent as Judge West reviewed the tragic details. She didn't raise her voice, but her words hit harder than any sentence could. She told No that his "I didn't mean to" doesn't bring the victim back. His case served as a sobering reminder that one careless